Hello friends, welcome to my channel. So today we are going to deal with the internal aids of interpretation of statutes. Interpretation is a process which is employed by the judiciary to ascertain or determine the meaning of statutes. The most fair and rational method of interpreting a statute is exploring the intention of legislation through text, subject matter, effect and reason of law. According to Salmon, interpretation is a process by which the court seeks to ascertain the meaning of legislature through the means of authoritative form. An aid is considered as a tool or device that helps in interpreting a statute. The court can take help of internal or external aid of interpretation. Internal aid means those aids which are available in the statutes itself. The court can interpret the statutes by exploring such aids. Title. Short title. The short title of an act is only its name and is solely given for the purpose of facility of reference. It is merely given for the identification of the act and not for the description, and generally ends with the year of passing of the act, such as Indian Contract Act 1870, Indian Penal Code 1860 and Indian Evidence Act 1872. Even though it is part of the statute, it has no role to play while interpreting the provisions of the act. It can neither extend nor it can delimit the clear meaning of a particular provision. Long title. A statute is headed by a long title whose purpose is to give the general description about the object of the act. Normally it begins with the word "an act to." For instance, the long title of the Criminal Procedure Code 1973 says that an act to consolidate and amend the laws relating to Criminal Procedure Code. In olden days, the long title was not considered as a part of statute and therefore was not an aid while interpreting it. There have been change in the time and thinking of the court in recent times, and there was numerous occasions when the help has been taken from a long title to interpret certain provisions of the statute, but only to the extent of removing confusions and ambiguities. In Popatla Shah vs. State of Madras, the title of Madras General Sales Tax was utilized to indicate the object of the act is to impose taxes on sales that takes place within the province. Amrendra Kumar Mohapatra vs. State of Odisha. The court held that the title of a statute determines the general scope of legislation, but the true nature of any enactment has always to be determined on the basis of its substance. Limitation of title as internal aids of construction. The title has no role to play where the words employed in the language are plain and precise and bear only one meaning. The title can be called in aid only when there is an ambiguity in the language. The title can prevail over the clear meaning of the enactment. The title cannot be used to narrow down or restrict the plain meaning of the language of the statute. Preamble. The preamble of an act contains the aims and objectives sought to be achieved, therefore is a part of the act. It is a key to unlock the mind of the lawmakers. The preamble is very useful aid to interpretation as it tells us about the true intention of the legislature for which the act was enacted. Its rules comes into place in case where the meaning of the enactment is not clear and more than one meaning is formed, but otherwise. In case of any ambiguity or uncertainty, the preamble can be used by the court to interpret the provisions of the statute. The apex court held in the Maharishi Mahesh Yogi Vedic Vishwavidyalaya vs. State of MP. The court cannot have resort to preamble when the language of the statute is clear and unambiguous. In Kerala Education Bill, it was observed that the policy and purpose of an act can be legitimately derived from its preamble. In Global Energy Limited vs. Central Electricity Regulatory Commission, it was held that the object of legislation should be read in context with the preamble. Rashtra Mil Mazdoor Sangh vs. NTC. The Supreme Court, while interpreting certain provisions of Textile Undertakings Act, held that when the language of the act is clear, preamble cannot be evoked to curtail the scope of enactment. In Keshwanand Bharti vs. State of Kerala, the apex court strongly relied on the preamble to the Constitution of India in reaching to the conclusion that the power of the Parliament to amend the Constitution under Article 368 was not unlimited and did not enable the Parliament to alter the basic structure. Limitation of preambles as an internal aids of construction. Preamble can be resorted to only when the language of the provision is reasonably capable of alternative construction. Preamble cannot either restrict or extend the meaning and scope of the words used in the enacting parts. In case of conflict between sections and preamble, the preamble would come and the sections would prevail. Preamble cannot be regarded as a source of substantive power of any limitation. Marginal notes. Marginal notes are those notes which are inserted at the site of the section in the act and expresses the effect of the act. They are also known as side notes. In olden times, help were used to be taken sometimes from marginal notes when the clear meaning of the enactment was in doubt. The modern view of the code is that the marginal note should play no role while interpreting a statute. The basis of this view is that the marginal notes are not the part of statutes because they are not inserted by the legislature nor they are printed under the margins under the institution or authority of the legislature. These notes are inserted by the drafters and many a times they are inaccurate. In Bengal Immunity Company versus State of Bihar, the Supreme Court held that the marginal notes to Article 286 of the Constitution was part of the Constitution. Therefore, it could be relied on for the interpretation of that article. Union of India versus Dilip Kumar Singh, the Apex Court held that the marginal notes apprehended to Section 47 of the Persons with Disability Act makes it clear that the idea of Section 42 was not to discriminate against employee who acquired disability during the service. In Taras Prasad Singh versus Union of India, it was held that the marginal notes to a section of statutes cannot take away the effect of the provisions. Limitation of marginal notes. Marginal notes are very rarely used in the interpretation as they are not considered to be a good aid of construction. Marginal notes can be used for constructing a provisions which may be inserted with the assent of the legislature. Marginal notes can be called in aid only when the language suffers ambiguity. Marginal notes cannot fluctuate the effect of clear provisions. Headings. In all modern statutes, generally headings are attached to almost each sections just preceding the provisions. For example, the headings of Section 437 of CRPC is when bail may be taken in case of a non-bailable offence. Headings are of two types. One which is prefixed to the section and other which is prefixed to a group of section. Those headings have been treated by the court as preamble to those sections or sets of sections. The rule applicable to preambles are followed in case of headings also while interpreting the enactment. Therefore, if the plain meaning of the enactment is clear, help from the headings can be taken by the court. Sarah Matthew versus Institute of Cardiovascular Disease. It was held that the sectional heading have a limited role to play in the construction of statutes. The heading of Chapter 35 of CRPC is not the indicator that the date of taking cognizance is the date on which the limitation period commences. In Novartis AG versus Union of India, the sectional heading was relied upon while interpreting Section 5, 3D and 83 of Indian Patent Act. In NC Rondidal versus Union of India, it was held that the headings can be relied upon to clear the doubt or ambiguity in the interpretation of the provisions. Limitations. Headings can neither cut down nor extend the plain meanings and the scope of the words used in the enacting part. Headings cannot control the clear and plain meanings of the words of the enactment.